Hello and welcome to our Lunch and Learn with Biztech Lawyers. My name is Charlotte Connell. I'm the Ecosystem Director here at Climate Salad. And before we get started, I'd like to acknowledge the traditional owners on the land of which we meet. For me, that's the Gubbi Gubbi people. And I pay my respects to their elders, past, present, and emerging, as well as any who are on the line right now. I will pass over to Yehuda from General Manager, Partner, Founder of Biztech Lawyers, who will talk us through this wonderful workshop on IP and data protection, which is incredibly important for founders.
Thanks, Charlotte. Thanks for the introduction. So I'm a special counsel at Biztech Lawyers. I'm based in Melbourne. I've got a few of our team from the Sydney office on the line today also. A little bit about the firm. So Biztech Lawyers, as the name suggests, we primarily work with technology companies. We're commercial lawyers with offices in the US, in Australia, and big plans to expand globally within the next 12 to 18 months to other tech jurisdictions. We work with a broad range of tech companies. We do a lot of work with climate tech companies, and often climate tech companies touch on, other aspects of technology. There might be fintechs that kind of cross over into climate tech, reg tech. So we have our wheelhouse broadly around technology, and that's largely why we're here today, to talk about a big element of technology, which is data. So without dragging on, I might jump into it. I'll just get the presentation up. Can everyone see? Charlotte, is that up and running now? Great. So today we're talking about data strategy for tech companies. Sorry, we've frozen.
Well, I was going to say that transition was absolutely seamless, straight to the presentation. Yehuda, is it okay if everybody post questions in the chat, or as well as questions at the end, or how do you like to go?
Absolutely. I mean, we might save some time at the end for questions. I'm happy for them to be posted, and we can save 15 minutes at the end to discuss anything. So just post as we go, and we'll get to them. Okay, so today, just a high-level plan of action. What we'll be looking at, types of data on a broad level, how data is collected and used, data and intellectual property, and how they often are very much interlinked. We'll have a brief look at the GDPR and its applications in Australia. Then data and risk flows and protecting against them, the importance of an internal data policy or strategy, and how to mitigate risks, and some of the solutions that we've worked with clients. You're sitting on more data than you think. I thought I'd open up with an interesting situation. So this morning, I was up early because my 5-year-old daughter woke me up early. And we were sitting there, and I was working on the presentation, and she said, "Dad, what are you working on?" And I said, "Well, okay, you've asked the question, I'll tell you, I'm working on a presentation about data." And she said, "Well, what is data?" So I then thought, okay, this is a great opportunity to try and explain it to a 5-year-old. So I said to her, well, data is, if someone takes a picture of you, that picture is then data. So she said, okay, and so what does that mean? So I said, well, let's think of an example. So you walk into the supermarket, and the supermarket has cameras, right? And those cameras are recording you. So those cameras recording you, that video is then data. So that data might then be used in many different ways, right? So it might show that you walk into the supermarket, you walk to the bananas, you stop at the bananas for a few seconds, but you decide you actually prefer apples. So you then head over to the apples. She was saying, okay, and so where is all this going? So I said, well, the question is then, well, what does the company do with that? Is that data yours because you're the person who they're taking a picture of? Or is the fact that they've taken the picture and now they own the videos, does that belong to the company? And her response was interesting. Well, it's definitely mine because I'm the person in the video. And so those type of questions of, what data is, how it's being collected, who owns it, and how it's being used, that's really, what we're here to look at today. So in terms of, what data is, we've got a big graphic here which sets out a lot of what data is, but data is really everything collected directly or indirectly. We've picked up this interesting graphic that was put out by McKinsey. It focuses on the banking sector, and it's around a data lake. Now, a data lake is really typically raw data, unprocessed, but it's a collection of data, and it looks at how and what data is and what might be valuable to a particular company. So in a banking context, for example, you've got your transactions, and how are those being collected, at an ATM, at a point of sale, and then, the type of people that are making the transactions. So your demographics, right, and who they are, what times of day, a particular group is making transactions. So there's multitudes of transaction data that banks would be looking at, and they're collecting them from various sources. Sales agents, the video analysis we spoke about, so customers walking around the shop, bank website data, call center, customer notes. All of this is data that, could be potentially valuable, might not be, might be. But at some point in time, all of this data is either directly or indirectly going to be collected by companies. We'll have a look at what that means, direct and indirect collection. So direct, so when we talk about the collection of data, we're often thinking about it from the perspective of, once you've collected it, what obligations does that trigger for a company? So typically, data becomes a concern or something that a company needs to think about if it's regulated. So that usually is when the Privacy Act comes into play. In a broader global context, you've got the GDPR. So that's around personal information that might be contained in the data. On the other side of the coin, you've got your intellectual property. So if you're collecting data, you want to make sure that the data you're collecting, it's clear who owns that data. So we've got a few examples here that I'll just talk to around direct and indirect collection. So for example, we've had a client that had a really interesting business model, actually similar to the example I described with the supermarket. Person would walk into a shop, cameras, and this is a real life example, cameras are tracking your movements in the shop. The notional idea in that situation is the company actually de-identifies. They're not interested in particular characteristics of a person, but they're just collecting body movements. So in that situation, you've got potentially an AI service that is looking at body movements, that those are being directly collected by the camera. So the camera is collecting those body movements. Now, the reason I said that the company is not particularly interested in this situation in specifics of the customer is because the indirect data that's being collected in that situation, which might be personal information, if it enables the holder to reasonably identify the data to whom the data relates, then that becomes personal information. And when you're dealing with personal information, you've got a higher regulatory obligation as to how you handle that data. So your indirect capture in that situation might be the customer's face, their gender, their age, their racial profile. And once you've collected that, you have certain obligations as to how you handle it. Another example, customers filling up a form that, for anyone in the room that's operating a SaaS company, you're going to typically have your customers engage through your SaaS terms, and they would, usually the process is they fill in a generic form, enter their information, and then that allows them to open an account. There you have the direct capture of data. The indirect capture that comes out of that is then their use of your website. So, anyone who lands on your website, you'll have a cookies policy, right? So your cookies policy will explain what's being done with that. And on a side note, there's been, a lot of push to kind of move away from the use of cookies, or push companies to have much broader disclosure about how cookies are being used and what they're being used for. And then on a deeper level, your indirect data is how people are using the service. So once they actually start using your SaaS service, good businesses are going to track the metrics. They're going to track how the product's being used, what applications are working, what applications aren't working. And you want to make sure that you are adequately covering yourself to allow yourself to be able to use all of that data. An example of that situation, so we've got a client that uses artificial intelligence to predict movements in the supply chains. And they actually broadly use it for predictions of all kind of risks that are associated with buildings. And it's actually a climate tech company, but it's broadly a reg tech company, because what they do is they then capture all of the data externally. So they go to the news, they go to the weather, they kind of broadly will scrape the internet and be able to use an AI platform that then predicts what kind of risks are going to affect a particular building. And then they will take all of that data and provide reports to help building managers and owners be able to plan for those situations. Now, in that particular case where they might be scraping the internet, they might inadvertently come across some sort of personal information. So, there's that balance between direct and indirect capture, and just making sure that whatever you're capturing, you're dealing with in the appropriate manner. For climate companies, unlikely that you're going to be dealing, in a patient-doctor situation, but often with, biotech or life sciences companies, we have situations where patient consent becomes really important, and that immediate data capture is that direct data capture of the patient talking to the doctor, reporting what's wrong with them. And then the indirect capture might be the company that sits outside of the doctor, that goes to the doctor and says, I'm doing a survey on the types of diseases in a particular area. And then how that data can be shared. The question then, the next step in the process is, what can you do with the data? so the pyramid kind of sets out the levels of care that are required at, with each particular data set that you're dealing. So at the top level, you've got sensitive personal information. So sensitive personal information is typically health-related data about a person. It might be, people could argue that gender or sexual orientation, these are kind of, really personal, really sensitive personal aspects of a person. So not only are they identifiable, they're actually sensitive. Now that requires the highest level of care. So in those situations, you have to be really careful with how and what you're doing with that data. The next level down is just basic personal information. As we discussed before, that is information that easily identifies the individual to whom that data relates. There is a high level of care that's typically in Australia set out in the Australian privacy principles. On a global level, that's the GDPR, and we'll look at that a bit later. De-identified information. Now, de-identified information is a particularly interesting subset. And that's really where we find a lot of clients coming to us to talk about what they can do once they've captured, might be sensitive, it might not be, but just personal information or potentially personal information. What are they actually allowed to do with that? Now, it can apply with personal information, and it can also apply where companies are just sharing data between themselves. So that de-identified information is where most companies really gain a lot of value, and they use that to improve their products. They might put that into their algorithms. They might use that information to help improve their products, help improve their code, help improve their user experience. And so that's where there's a lot of complexity around thinking through what data you have, what you're acquiring, and what you're planning to do with it. Because oftentimes what we'll find is, let's say, for example, you've got a company that is tracking a supply chain. Now, as they track through that supply chain, there's various actors within the supply chain. So as an example, we're working with a company that is independently verifying a supply chain so that at the point of sale, a company can verify that the products have been ethically sourced. Amazing technology, but very complicated data iterations because they are collecting a lot of data. They are hosting that data for an external purpose, which is to share that independent verifiable information. But as every good company wants, they also want to be able to use some of that data to be able to improve their product. So there's that kind of distinction that needs to be very carefully thought out between the information we've collected in this particular context, how you're going to share that information, and then beyond that, how do we legally and ethically use that information within our own business? And then the lowest rung is really non-personal information, company proprietary data. That's if you are just coding your own software, or you're just generating data that has no personal information in it, then that kind of requires the lowest level of sensitivity. So the next point that we look at, and touched on it a little bit, but really data, the way we see it, is fuel for tech companies, and having a data strategy in place early on in the piece is often extremely beneficial, and it can make a lot of difference in the long run as to how the company sets itself up and understands its product and understands its engagement with the outside world. So the way we typically engage with this, we might look at InfoSec and cybersecurity policies. We'll touch on a few examples of how the cybersecurity landscape is changing and potential risks of not getting that right. Data sharing and processing agreements, that's really important. You know, if you're a company that relies on big data sets to generate or improve your algorithm, you might be getting those data sets from a university, as an example, or from a government department. Now, they'll often have their own data sharing agreements. You just want to make sure that when you're accessing those data sharing agreements, that you have the rights that you need to be able to do with them what you want to do with them. Sorry, I can see there's a few questions popping up. I'm going to just hold off until we get further on. Oopsie, sorry about that. Intellectual property agreements, again, you know, that data importantly forms the basis of your product. Very important to make sure that you own that intellectual property, because oftentimes there can be, and we have seen this multiple times, particularly in that data sharing context where companies might take a data set, they might, you know, do a collaboration, and they don't realize that the data that they think they own, they actually don't own. So very important to put in place all of these strategies up front. Standard terms and conditions, that's how you engage your customers typically. You know, that's customers, that's consumers, suppliers. Those are kind of your more standard terms around what you can and can't do with the data, and explaining to the outside world how you deal with that data. And then regulatory compliance and risk management, again, very, very important. We'll have a look at some examples of that changing landscape and where things can go wrong. So we've just got a little graphic over there. Often startups sometimes do, sometimes don't appreciate these type of graphics, but you know, we think that it's just really important to have your data strategy set up correctly. And I think the first step to doing that is really just thinking about it. It's really just thinking through all of these issues. The worst strategy you can have is no strategy at all. And so if you're kind of starting up a company or you're scaling up a company, even if you've been doing something for a while and you've been doing it really well, it's often a good time to just take a step back. And you know, you might be looking at a capital raising, you might be looking at a transaction coming up, and we often will help you and say, okay, you know, this is what an investor is going to look at. This is what you might look at a strategic merger. You know, in a strategic merger, any partner you're going to look at is going to look at X, Y, and Z factors within your data strategy. And then, you know, we can help fix that up. And often these situations are easier to fix early rather than later. We'll get on to GDPR, and I might kick over to Anthony Becker to jump in here.
Hi, everyone. Thanks, Yehuda. So in terms of GDPR and the existing regime that applies to personal information in Australia, what would be maybe not clear is that at the moment, Australia lags behind the rest of the world, or a lot of the rest of the world, in particular the EU, in relation to privacy regulation. And the GDPR really sets a high watermark for privacy regulation globally. There's a number of aspects of the GDPR that are not captured so well in Australian law, and we'll touch on it in a second, in particular, the roles and responsibilities of processors and controllers, which is those concepts just don't exist in Australian law. And I guess the key thing to know is that it's expected that Australia will implement something like a GDPR regime in the coming months, if not years, depending on how quickly the new government acts. But there was a Privacy Act review undertaken by the Attorney General in the last government, and there's a lot of push within that process to develop GDPR equivalent legislation, if only to make things consistent globally. And we think actually it would be much easier if that happened. The other thing to know is that the GDPR could also already apply to companies who are doing business there or have customers there. So it's something to keep in mind. In terms of the actual roles of processors and controllers, it's an interesting one to think about because it sort of helps structure how you think about the chain of custody of data and who's doing what on whose direction. And you know, when we write privacy policies for Australian companies, or we're helping them with their data strategy, some of this thinking is helpful to place them, you know, help develop the sort of way that they think about the processing of data. So in the EU, you've got the concept of a data subject, a data controller, and the data controller is the one who, you know, is directing the data processor as to how that data should be processed and on what terms. I guess the other thing to know is that in the EU, both data controllers and data processors have liability for the you know, breaches in respect of data as well. There's also notifiable data breach regimes in both countries, but the thresholds for notifiable data breaches in Australia are much higher than in the EU, where you need to have in Australia a risk of causing a serious harm, which is quite a high threshold realistically. And then you have 30 days to make an assessment as to whether or not you need to report the breach to the Office of the Australian Information Commissioner and to the data subjects concerned. In the EU, you have 72 hours to make that assessment. And the assessment needs to be whether there's a real risk to the rights and freedoms of an individual, which is a much lower bar than causing serious harm. So in either market, you need to take mitigation steps, and you know, having a robust internal governance process is important for that. Monitoring, data loss prevention, making sure that your systems are well secured is super important. But that's probably another thing that will change with a change in law in the coming months, if not year or so. Yehuda, did you want to touch on this slide?
Yeah. So we're getting into the kind of case studies now of, you know, things that can go wrong and do go wrong. I'll just, as a general comment on these, you'll see that the fines often, in terms of their financial value, are not particularly high, particularly for bigger companies that can't afford them. But in these situations, it's often not financial damage that's caused by these data breaches as much as it is reputational damage for these companies. So data breaches typically, I mean, they affect over 3 in 5 small companies. Most companies don't even know when they're being affected by a data breach. So one company we looked at was the Hartford Hospital, which faced a $90,000 US dollar fine because a laptop containing data on patients was stolen from an employee's home. The financial penalty, probably not so high, reputationally not great, and also from the perspective of understanding the level of care that's expected, that really sets a high watermark. I mean, that obviously extends to your employees and how they deal with it, and that's why having a privacy policy that's outward looking is important, but having an internal policy that deals with your employees and how they engage with data is equally as important. This is an interesting case that happened recently in Australia. A company called RI Advice. There were recent amendments to the Critical Infrastructure Act that made company directors personally accountable and potentially liable for cybersecurity breaches. So effectively what the court is looking to do is extend Corporations Act directors' duties to say, well, if you have a duty of care, that duty of care includes making sure that you have appropriate cybersecurity protections. A company called RI Advice, which saw several incidents of ransomware, payment fraud, business email compromise, just didn't take enough precaution in preventing those from happening, and was required to pay a reasonably hefty fine in damages and ASIC's legal costs. The Australian Cybersecurity Centre is putting out new guidelines all the time about best practice in managing these risks, and I think it is something we can certainly help companies understand, and we do work with companies on putting in place strategies and protections to mitigate against these. Bigger case globally, which I'm sure most of you know about, Facebook's $1 billion fine for the Cambridge Analytica scandal. That was really big. I mean, that kind of changed a lot of the landscape of the way big tech operates. The US government got involved after that. Over 300,000 Australians' data was exposed. And I don't think we've actually seen the end of it. I think there's still ongoing claims that are being brought in that regard. What was interesting about that particular case is the hearings in the US. It was quite stark to see and understand how little the government actually understood about what tech companies are doing, to the point where in the Commission of Inquiry, where Mark Zuckerberg was being questioned, one of the senators who was questioning asked a question: how does Facebook make money if it doesn't charge its users to use the service? And that was really interesting, because that kind of gave a bit of insight into the fact that there's a whole part of the regulatory world that just doesn't actually understand how technology companies are using their data and how that data is being monetized. So yeah, there's a piece over there that is ongoing in a bigger picture sense about working out, what should be regulated, shouldn't be regulated. And that's kind of a wait and see situation. Another example, Grindr. So they received a relatively hefty fine of 7.1 million for a GDPR data breach. And in their situation, they actually did what a lot of tech companies are doing, and they gave user data to advertisers, but they did it without consent. And in that situation, you were talking about sensitive personal information because the information they were handing out related to sexual orientation. And I think that probably pushed it up a little bit in terms of its seriousness. The complaint was focused on how the app obtained consent. So users did not have a free choice to agree to terms, as they would not have been able to use the app unless they accepted its privacy policy. Again, a really interesting one, because every company will have a privacy policy. Most companies will say you can't, use our site unless you agree, unless you agree to our terms and conditions. I think the lesson out of the Grindr case is that not all terms and conditions are created equally. And it is really important, if you've got a privacy policy or you've got terms and conditions, you don't have to look at them every month, but it is important to keep up to date with regulatory changes and make sure that you're updating as you go to not get caught out or left behind. Red Doors, so that was a hotel company, and in that situation, they failed to prevent theft of personal data, and that was really just a hang up from their startup days, when an AWS key was embedded into a test app's application package, which is the Android service. Took a long time for the breach to be noticed, but by the time it was, they had exposed 5.9 million hotel customers. So again, and I think that's probably a really good example for a lot of startups, because you kind of are very busy in the early days, creating your code, getting things done. Often just workarounds on software, not thinking about all of these things. And they can certainly come back to bite you later on. We've spoken about this at a high level. What we do with companies is we work with them to put in place these strategies and then execute on those strategies by working out what consents you might need, whether that's consents from your data subjects, whether it's consents from other companies, or whether you're working with partners and you're obtaining information through them. You need to then put the obligations onto them. The risk, so mitigating, scoping out what your risk is, where it might be coming from, and then mitigating against that. We often do that by putting in place the correct agreements. Those might be data sharing or processing agreements, intellectual property agreements, looking at assignment or licensing of IP and making sure you have clear rights, your privacy policy, and then generally security, which is broader than your legal agreements. That's actually your oftentimes your security processes. We work with companies at every stage. We get involved at the earliest stages. That's when you're a startup and you're just starting out, or you might be scaling up. We have the ability, and we enjoy working with companies from creation all the way through to that global scale. We've worked with a number of companies. Some of the companies in here you might recognize. I believe some of our clients are actually part of the Climate Salad network. And that's it. And I think I might hand over to Anthony to just say a few closing words, and then we can take questions. You're on mute, Anne.
I knew that had to happen at least once during this conversation. Thanks everyone for the time, and we're really committed to the climate tech industry. It's obviously a massively important sector, and we're also a member of the Tech Council, in order to affect change at, not only for our clients directly, but at a regulatory and policy level with government. So happy to open up the floor to any questions, and if we can answer any of your questions about data or anything else, not legal advice, of course, but happy to discuss anything that you're interested in.
I've got a question. I'm Louise. I'm from Hygiene Renewables, and we're a deep tech startup company. I don't know if this is in your domain, but what we're doing at the moment is licensing some IP from a university, and one of the clauses has got to do with cybersecurity and insurance. And just trying to get my head around what level of protection we need against, anything that potentially could go wrong. What does that liability limits look like? And I mean, it was really fascinating to hear all these huge fines and stories, and we don't want to be in that place, but how do we protect ourselves from such events? And what do you advise your clients from an insurance perspective?
So, well, first and foremost, it might be something that you want to take offline if there's details about it that you don't want to share, and I'm happy to have a conversation afterwards. The other interesting thing is Yehuda is actually ex Monash in-house counsel, so he's sat on the other side of those university licensing transactions. So we'll definitely have something interesting to say. The privacy law talks about, I guess the privacy law regulations are separate to the contractual, requirements that you're being asked to fulfill. In all likelihood, the privacy law itself talks about reasonable measures, and what's reasonable depends on the circumstances. The specifics of your contract, we'd recommend someone, you going through that with a lawyer as to what those words explicitly say. It's probably hard to give general advice. But
no, that's really helpful. No, I've got a call with my lawyer tomorrow. We started off with a clause that said, a reasonable level of liability, and now there's been a number put in there, which I cannot get an insurance policy for that liability limit. So I'm not sure if it's just an extra zero added in, or what is reasonable for an early stage company. But look, I do have a call with my lawyer tomorrow. I just was curious to hear what you see in general for these kinds of insurance policies for cybersecurity. Does the industry have kind of limits on the liability that they will insure at? Or?
So for insurance specifically, it really depends. It's often tied to cyber policies are often tied to professional indemnity policies, and it's really like, how much are you willing to pay? If you're, if you can get a $10 million policy or a $20 million policy, if you're willing to pay that much for it, but the cost becomes very prohibitive very quickly. So, even for big companies, they are pushing to have insurance limits at max $5 million. 10 is very high. 1 is more common.
Yeah, no, they're the numbers I've sort of understood was standard, and that's actually really helpful to hear that from you.
Yeah.
Yeah, thank you.
Yehuda, do you want to talk about the sort of university context?
Yeah, I mean, we've had some interesting situations come up, particularly in that university context, because you're often dealing with very large data sets, and universities or any research institutes are often very kind of funny about how they want to share those data sets, because they want to do their research on it, and they don't particularly understand the commercial elements that can be derived from those data sets. So I think there's often a process involved of educating, and I think transparency in negotiations. So, for each party to understand what it is that they're going to be doing with the data. So a university, wants to do research, and that's great. So they might want to be able to retain the ability to use the data to carry on doing research. What they might also be very careful of is managing risk. Universities are typically very risk averse. And so to that extent, they would be, it's not surprising, they want you to take out, insurance. But I think what I would be dealing with in that context is giving them an education piece and understanding what the actual risks are. Because oftentimes you're dealing with a commercial person internally at the university who doesn't necessarily understand the risks. They're kind of, being told one thing from the higher ups, and there's a big hierarchy. And if you can kind of get through the process of actually explaining what it is that you're going to be doing and identifying the risks in as much detail as possible, you can often walk away from having these crazy policies that are required that actually don't make sense.
No, I think that's exactly where we're at. It's for us to sort of make that case as to exactly what we're doing and what we think the risks are, and happy, like, we want to protect ourselves, don't get me wrong.
Yeah.
It just feels like it's a number that's been plucked out of the air without any rationale from the university's perspective as to why or what the thinking is. It's very, very hard to understand.
And I think that applies. I think that applies generally when it comes to a lot of data negotiations, not just in the university context. We find a lot of it is educational, because companies, even tech companies, don't necessarily understand data and its applications fully. They're often learning about what they have and what they can do with it as they're going. Or they might realize that they actually are accessing data that they don't have the right to, or that they find a data set that they need. And so oftentimes, it is that kind of ongoing education piece with partners and collaborators, and making sure that everyone understands as much as they can at each step of the journey.
Thank you.
Very good.
Charlotte, were there any other questions?
I just had that one before about, and sorry, I know a few had to drop off with meetings, and I appreciate founders are always scarce on time, but just with those data sets going into the different scope, like scope 1, 2, and 3 emissions down, I mean, it's not going into personal data, so that would be okay. Yes? Is a general answer for carbon accounting? Could it be that personal information is how much meat you eat from the team in the future will be held against you?
I mean, it's a hard question to answer, and we're working with a company at the moment that is developing an algorithm that tracks carbon emissions based on point of sale purchases. So in essence, what you would be able to do is you would be able to know if somebody buys a steak, for example, how much their carbon emission is for that particular steak. And I suppose the flip side of that is the company that controls their payment account would know that person is buying steak, and therefore would be able to say, well, that person is a huge carbon emitter. So yes, technically it could be considered personal information. And in the future, are we going to see people being called out as being polluters? Because
is it going to become in the future more sensitive than sexual orientation?
Well, it might be if companies are starting, and this is where that intersection of making sure, it's used in the right way, because if companies have the ability to track a person's carbon outputs, then those metrics might be able to be used against them.
I think there's a critical test in the Privacy Act about what constitutes personal data. And it's really a common sense test, which is, does this data allow me to identify a particular individual? So normally, things like name and address and email address or phone number are, in combination, either alone or in combination with each other, are the core things that constitute, or would, if linked together or with other things, would mean that those are personal information in and of themselves, and or the other data that they're connected with or are also personal information, if you have enough of those core identifiers to actually identify a specific person. Saying that Tom Smith, there might be 100 different Tom Smiths who have varying carbon emissions of varying levels. But if it's Tom Smith who lives at this place and has this email address, has this level of carbon emissions, then arguably that carbon emission data linked to that specific person who lives at that specific address becomes identifiable. And that's the threshold that you get to, and when you have to start dealing with the information as personal information in accordance with the Privacy Act. But if it's not associated with a person, or they're not reasonably identifiable, then you're outside of the realm of the Privacy Act. So that's how we think about it.
Okay. No, it's good. I mean, I'm looking at Trace. I personally offset with Trace, and I know that I've worked with Trace with businesses where they go through the, all staff members, but and have the data collected on, the total team's carbon emissions or personal footprints, but team members aren't identified individually or personally. So, yeah. But I won't hog all the questions. Are there any questions from the floor? Are there a lot of information to take in, and it's great to tap into your planet-sized brains about this incredibly important area, because it's one that if you get wrong, you could be up like Mark Zuckerberg for a $5 million fine. So you do actually really want to get it right. What about when companies are first starting out? Is there any sort of, sorry about that. Is there any hot tip that you can leave us with to consider, apart from obviously, contact Yehuda on Slack and have a little chat, or, get into his Calendly or employ their services. But is there any sort of hot tip you can leave us with?
And do you want to shoot something?
I guess the data strategy slide sort of sets out a range of things that go into what a data strategy is, and depending on whether or not you're collecting personal information or not, it really affects all of the different aspects of your business. So it's a really threshold question for a business to consider. That's fundamental to the business strategy, and thinking about that issue early on in your business will help you in the long run in lots of different areas across contracts, policies, procedures, all of that stuff. That's my hot tip.
Consider it early, not as an add-on later.
Yeah.
Damien, your camera's just come on. Did you have a question before we go?
Yeah, just a very quick one. I know we've only got a couple of minutes, but it sounds like you guys obviously offer a range of different services, and there's lots on offer from different cybersecurity companies. But for an early stage startup, obviously there's a lot of investment in time and money required. Where do you recommend kind of starting for an early stage startup on the cybersecurity journey, given that there's a lot to do in the long run?
From my perspective, understanding your data flows and having like that sort of on a more policy practical perspective, and that sort of is how we would start thinking about what policies to institute and what your privacy policy is, for example. I guess on a purely cyber security basis, I am highly unqualified to advise on what specific cyber measures should be put in place. But I know that
more broadly, I meant, sorry, not specific
Yeah.
cyber, but just data protection broadly in the legal side.
You know, the test in the law is taking reasonable steps, and it, you know, will depend on what your circumstances are. Most companies are regularly, you know, doing penetration tests of their systems and having their security checked. They'll have mock cyber attacks that they undertake, and they might try to test their staff to see if they're prone to handing out information to fake phishing attacks. So there's sort of a whole series of, there's a sort of program of activities that cyber professionals take companies through when they're helping them enhance their cybersecurity posture. So that goes sort of hand in glove with the legal efforts, which are, you know, policies, insurance, and governance procedures in respect of data. So I guess you approach it from the legal side and also the practical cybersecurity side.
Sure. Thank you for that.
How does that sit with
start
approach?
with everything. Look, I know that there is no easy answer, is why I'm sort of asking if there's any tips or advice, but yeah, I mean, there's obviously a lot of facets to it. So
yeah,
I think the general message is, you know, if you're thinking about it and actively engaging with your data and the way you use it, the way you collect it, you're already 10 steps ahead, just in terms of putting in place whatever you need to be able to protect yourself and your company.
Mm-hmm. Cool. Thank you.
If there's one last question coming from the group, fire up, just turn off your microphone or your camera so I can see that you're about to ask a question. But otherwise, thank you so much for this this workshop, and just taking us through a sort of a broad brushstroke of what you guys do, and also you know, just a hot tip, if anyone's planning to expand to the US, Biztech Lawyers also have an office there. So thank you so much for your time today, and I'll have this recorded and I'll share it out through the Founders channel.
You're welcome. Thanks, Charlotte, and thanks everybody. And yeah, be in touch.
thanks.